Selamat sejahtera to Mr. Wasfi, our lecturer. Today we're going to present our presentation, Company Law Dpb30083. Question 3. Compulsory winding up by court. Question A. Several types of petitions having local standee. Local standee is the right of a party to appear and be heard before a court. Section 464 of the Contract Act 2016. So, there are 9 persons that can make local standee. The first one is the company. The second one is any creditor, a contributor, personal representative, trustee, director general of insolvency, the liquidator, the minister, the licensed institution, the operator of design payment system, the registrar, and the member institution under the Malaysia Deposit Insurance Corporation Act 2011, PIDM.
Hi, my name is Arabella Grace. I'm a second presenter. Question 3b, several grounds or circumstances for compulsory of winding up. There are 12 grounds listed as the circumstances for a compulsory winding up as according to Section 465 of Companies Act 2016. Subsection A, the company passed a special resolution that the company is to be wound up by the court. Subsection B, the company default in lodging the statutory declaration. Subsection C, the company does not commence business within a year from the date of incorporation, or the business has been suspended for a whole year. Subsection D, there are no members in the company. Subsection E, the inability of the company to pay in its debt as discussed further Section 466, Subsection 1 as follows. Subsection 1, neglects to pay the in-debt sum exceeding 10,000 after receiving the notice of demand from creditor and notice period of 21 days has expired. Subsection 2, the company failed to satisfy the execution or the other process in favor of the creditor. Subsection 3, the court is satisfied that the company is unable to pay the debts. Subsection F, the director act for their own interest. Subsection G, the company expire as being stated in the Constitution. Subsection H. Subsection J, the company has carried on without being duly licensed, or it has accepted, received, or taken deposit in Malaysia in violation of the Financial Services Act 2013 or the Islamic Financial Services Act 2013. Subsection K, the company is being used for any unlawful or prejudicial purpose, or is incompatible with the peace, welfare, security, public interest, public order, good order, or morality in Malaysia. Subsection L, declaration has been made by the Minister under Section 590. That's all from me. Thank you.
Hi, my name is Emilia Asang. I am the third presenter. Next is question 3C, which is relevant cases. According to section 465, subsection H and subsection 1, the court is in the opinion that it is reasonable that the company be wound up when the substratum of the company is gone or can no longer be achieved. The relevant cases is Perry against Stewart. a shipping company lost in its only ship with the remaining asset of €363. Minority refused the petition of winding up made by the majority shareholders. In such a situation, therefore, it was just and equitable that the company be wound up. Next is subsection 2 Roman. The management is carried on in such a way that the minority is disregarded. Relevant cases is Ibrahimi against Westburn Legaris Limited and others. The company consists of two shareholders, Nazar and Ibrahimi, where both of them are the shareholders and directors of the company. They were not paid any dividends, but received wages for their services. Later, Nazar's son joins the company as a shareholder and director, and now father and son control the company. They terminate Ibrahimi, which caused him loss of income. Ibrahimi made a petition to wind up the company. It was held that when Ibrahimi and Nazar set up the company, it is on the basis that the nature of their relationship will remain the same. Despite the facts what the Nazars did was perfectly legal, it was just and equitable that the company be wound up. Subsection 3 Roman. There is a deadlock in the management of the company. Relevant cases, Yaniji Tobacco Company Limited. There are two sole shareholders and both are directors of the company. Later, there were disputes in which communication was no longer made between them but through the secretary. Regardless of this, the company made substantial profits. The court decided then that mutual confidence had been lost and the company should be wound up. Subsection 4 Roman. The company was formed to carry out fraudulent or illegal business. Relevant cases is Brinsmith, Thomas Edward and Sons. The company, which is John Brinsmith and Sons, was a piano maker. However, at the same time, their three employees set up another company to manufacture and sell the pianos. It was then decided by the court that the company was formed with the purpose of committing fraud and should be wound up. Next is question 3D. Differences between compulsory winding up and voluntary winding up. First is compulsory winding up. Refer to section 464, subsection 1 and subsection A. By presentation of a petition in the court. Reason is, refer to section 465. Section 465, subsection 1 and subsection A, the company passed a special resolution that the company is to be wound up by the court. Section 465, subsection 1 and subsection B, the company defaults in lodging the statutory declaration under section 190, subsection 3. Section 465, subsection 1 and subsection C, the company does not commence business within a year from its incorporation or suspend its business for a whole year. Section 465, subsection 1 and subsection D, there is no member in the company. Section 465, subsection 1 and subsection E, a company is unable to pay its debts. Section 465, subsection 1, subsection F, the directors act for own interest. Section 465, subsection 1, subsection G, the company expires. Section 465, subsection 1, subsection H, the court decision for the company to be wound up. Section 465, subsection 1, subsection I, the company license under the Financial Services Act 2013 or Islamic Financial Services Act 2013 being revoked. Section 465, subsection 1, subsection J, the company has carried on without being duly licensed or it has accepted received or taken deposit in Malaysia in violation of the Financial Services Act 2013 or the Islamic Financial Services Act 2013. Section 465, subsection 1, subsection K. The company is being used for any unlawful or prejudicial purpose, or is incompatible with the peace, welfare, security, public interest, public order, good order, or morality in Malaysia. Section 465, subsection 1, subsection L. Declaration has been made by the Minister under Section 590. Next is voluntary winding up. Refer to Section 432, subsection 2, subsection A. By a member's voluntary winding up, where the company is solvent and the liquidator is appointed by the members at the members' meeting. Refer to Section 432, subsection 2, subsection B. By a creditor's voluntary winding up, where the company is insolvent and the liquidator is appointed by the creditors at the creditors' meeting. Reason is Section 439, subsection 1, subsection A. Subsection 1, Roman, the expiry of the period fixed by the Constitution, or subsection 2, Roman, the occurrence of events provided by the Constitution that the company is to be dissolved. Subsection 3, Roman, Section 439, subsection 1, subsection B. The company has passed a special resolution in a general meeting for the company to be wound up. Categories divided into two. Refer to Section 432, subsection 2. First is members' voluntary winding up. Second, creditors' voluntary winding up. That's all from me. Thank you.